All right, let's see if we can get through this.
Continue to October 27th at 2 p.m. for filing and motion. Thank you.
Thank you.
Hey.
Call, what's it, Johnson and Johnson?
Okay, are they all here?
I don't know, what else do we have?
Are they ready on?
Now, let's see if we can move some of this other. Do you have anything that they're ready on before we launch into something? Okay.
Okay. Where
we go.
Numbers 4, 5, and 15, Commonwealth versus Aidan Kearney, 23 CR 313, 24 CR 43, and 25 CR 88. If the parties could please come forward and identify yourself for the record.
Mr. Cosgrove, Mr. Kearney, how are you? All right. We have Robert Cosgrove representing the prosecution, at least for the moment. We have Jim Bradle, who's here, Mr. Starow from New York, and we have Mr. Kearney. Before us on the one of the cases, I know you moved to withdraw, Mr. Cosgrove. Which one is that?
I'm sorry, I didn't hear the very last thing.
Yeah, you moved to withdraw on 240043?
Yes.
No objection, Your Honor.
All right.
No objection, Your Honor. He wasn't even asking. He just wanted that in. What's happening here in the Aidan Kearney case is that Krusty is suing everyone. Everyone. Because now apparently everybody is conspiring against her. Isn't that interesting? Making it more or less, it's making it unless they find a prosecutor outside of the county that wants to touch this case might be over. Personally, I want more discovery. But folks, this is extremely expensive for Aidan, this case. He has fundraised a lot of money to defend himself. And yeah, it really helps. But he has lawyer costs that way exceed what we managed to fundraise for him. But oh, sorry, not Krusty, Lindsay Gaetani. Lindsay Cantani is suing everyone. That's the one. I'm having a difficulty between them because for me it's more or less the same person. Now I do know that Lindsay is desperately trying to differentiate herself from Krusty, but for me it's basically the same person. So that is why, they were excusing themselves.
So on 240043, based on representations, Mr. Cosgrove is allowed to withdraw. Now, Mr. Cosgrove, have you had any communication with the Norfolk DA's office on who's going to take that case over?
I have, Your Honor. My present understanding is that no decisions have been made.
There was another motion to withdraw I saw from another name I was unfamiliar with. Was that Mr. Mello's partner?
Novak, Your Honor.
Mr. Novak, who I haven't seen during any time that I've been involved in the case.
Mr. Novak, Your Honor, is a gentleman who I believe filled in, I'm not sure I have this right, but this is my recollection, filled in for Mr. Mello on one day when he was ill, I think before the grand jury, and entered an appearance for that reason. He's had no further involvement with the case, and I think it was just a matter of cleaning up the docket.
Helping out Mr. Mello. So I obviously, pursuant to the motion to disqualify Mr. Mello that I allowed, I'll let Mr. Novak out of the case. So, Mr. Cosgrove, I trust that you'll have communication with the Norfolk DA's office about a new prosecutor coming in on 240043. That's the domestic allegation.
They are aware of it, Your Honor. I think as I'm about to leave the case, it ceases to be my problem, if I can be so blunt. But
You can be so what?
someone, I'm sure, will be in touch with the court.
All right, I'd call upon the Norfolk DA's office to see if they can have somebody appointed on that case.
Yes,
And do it forthwith. I'll make an order to that effect.
all right. I understand, Your Honor. I will just say that since, as you are probably aware, the reason for my withdrawal is that the alleged victim in the case is attempting to implead.
See the difference in how he is addressing Lindsay? Throughout all the proceedings, he has always called Lindsay the victim. Now, when her actions is throwing his out, all of a sudden she is alleged victim. Telling me, and should tell all of you, he never believed Lindsay was a victim.
In a civil suit between her and Mr. Kearney in the Worcester Superior Court. The situation does not seem to me personally, and I'm not speaking for the office, conducive to enticing the special prosecutor to assume my position. So I will have to see what develops.
Okay.
Imagine if Morrissey... Here's the thing. Lindsay is suing Morrissey as well. And then more or less the entirety of the DA's office. So technically, I'm not sure they can appoint a special prosecutor or even try to hire Brennan again. Because she's suing the entirety of the DA's office through Morrissey. So, yeah. My personal opinion is that Cosgrove here is just stalling. Everybody in that office knows they're fucked. But they're stalling because that would mean another hearing and more costs for Aidan. That's all this has been. If they can't get into jail or prison, at least make it everything as expensive as possible, which they are failing at, but they are grasping at straws. Anything, everything. Now, Lindsay is just self-preservation. She has to make herself the victim. She was bad at it in the case here, really bad, and everything would have come to light anyways. But this is her stalling everything.
I'll make an order, Margaret, just as to 240043, the order of the court that the district attorney appoint a special prosecutor within 30 days.
Judge, if I may, we'd just like to be heard on that very point.
Yeah, go ahead.
Attorney Beddow is going to address that, Judge, just in terms of the potential conflict extending all the way to the DA.
All right, go ahead, Mr. Beddow.
Judge, the problem with this situation is that the alleged victim, who is dragging Mr. Cosgrove as Detective Lieutenant Tully, as part of these series of legal maneuvers, sent a demand letter to Michael Morrissey in his capacity as district attorney, presenting claims against the DA's office arising out of the same incidents which have left Mr. Cosgrove to leave. And it's a classic demand letter. If something's not done within 6 months, she intends to take legal action.
And this is to the Norfolk DA.
This is to Michael Morrissey in his capacity as district attorney, and we believe that the Norfolk DA's office now has an irreconcilable conflict, because it would lead to questions about how are they in a position as a future potential litigant
Yeah.
to start appointing people. So
Why don't you do this? Why don't you write up something and put something in writing to show your opposition? Obviously, I'm not going to. I think it makes sense for the district attorney's office to review whatever it is that you file and then make a decision on that. Okay.
that the last concern with that is at the moment, because Your Honor disqualified Mr. Mello recently in the decision. Mr. Cosgrove has been relieved, and this Mr. Novak has been relieved. This case, the 24 indictment, at this point in time is essentially stateless. There is literally, and I want to overuse the word literally, there is literally no prosecutor on that case for an indictment that is approaching a year and a half, almost 2 years old. There are still outstanding discovery issues, and obviously Mr. Cosgrove is no longer in position to deal with those.
Yeah.
But we just want to get this remedied as quickly as possible.
Yeah, no, I agree. So I think I'm pretty comfortable with my ruling that within 30 days, someone has to appear from the Commonwealth.
Okay.
Whether that's the Attorney General's office or another prosecutor's office or somebody, but somebody has to come.
Thank you.
I agree with that. All right, now we're going to the other two cases, which are 23-00313 and 25-0088. I think we're on today for discovery motions on that. I know that you have filed a motion to dismiss. I'm sure Mr. Cosgrove hasn't had a chance to respond to that because it was filed within the last week.
We've had some discussion about that, Your Honor. And if the court is agreeable, we have some suggested dates. I believe that we have agreed on a filing date of a non-court date.
I'm not exactly sure what Lindsay is suing for, because I only saw her lawsuit through people on X and commentary around it, and I skimmed through a bit of it, and it's not entirely clear, but it's more or less they conspire against her. Everyone, including Aidan, including Karen, including Proctor. Everyone is conspiring against her. it's so, yeah. It's self-preservation. She is, to my knowledge, representing herself, and probably because there's not a lawyer in the country, besides maybe Ginger Ass, who would take her case, because it's stupid.
Non-appearance date, but a filing date of October 27th for the Commonwealth to file a response to the motion.
Brandon is here. Hey,
And then I believe that both
get well soon, Brandon.
defense
Get well
counsel
soon.
and I would be available if it suits the court on either November 12th or November 14th to hear argument on the motion.
Margaret, what is the court schedule like for those days? With Walsh?
Oh, Brian Walsh case.
No, it's going to have to go through the regular course. Give me a date later in the month.
I think that's December.
Yeah, because the Walsh trial is going to start, and
Yeah.
I think October 20th, and that will take care of this session for a while.
Is October 20th work?
No, we're talking about Mr. Cosgrove having the hearing later in the month of November. The filing date's fine.
Right, so
Later in November, Your Honor?
Yeah.
They didn't think they were going to be available till December.
yes, I mean, the
Oh, is it-
following week is Thanksgiving week.
Yeah, okay, then go into the first week of December.
Any day but the 4th.
Well, that suits me because I can't come on the 4th. So,
The 5th, okay?
Friday the 5th?
Yeah, does that make sense? All right.
Is it
Okay, so Friday, December 5th.
non-evidentiary motion to dismiss?
correct.
Yes, I think it's non-evidentiary at that point. There's a prayer in the motion for an evidentiary hearing, but I assume the judge would make a decision as to whether or not to grant that based on the argument on the 5th.
I'll be at 2 p.m.
Okay, what else do we have? Do we have any?
There are two other matters, Your Honor, that I'd like to raise with the court. One is a motion for a protective order for certain investigative materials. I have just...
Is this the Brady list?
yes, it relates to the Brady list.
Yeah.
Oh.
I have just served the actual motion. The attachment was previously provided to the defense, but I believe Mr. Bradel wants to, is okay with taking it up today and wants to be heard briefly on it.
Yeah.
And I'll rely on my written submission.
Okay. So what we have before us is a motion for protective order relevant to certain internal investigatory materials, and that has been presented today by Mr. Cosgrove. Mr. Bradel, go right ahead.
Thank you, Your Honor. As the court will certainly remember, we've maintained our objection about public materials,
Right.
about public officials, that, you know, the risk of embarrassment, et cetera, is not a grounds to, you know, hide something from the public. And, you know, a lot of this stuff, the trend has been in the last few years to make police misconduct issues publicly accessible. So, you know, Mr. Kearney shouldn't have less rights than everybody else out there. There's no First Amendment exception for Aidan Kearney that he can't have things that the public can have. So this is one of those issues where, you know, we maintain our objection that there's no reason to impound these items. And the stated reason that, oh, Mr. Kearney might talk about these issues is not a ground, and it fits under the rubric of public officials' misconduct should be out in the public sunshine, and that's that. So it's not a ground to say, well, Mr. Kearney's going to talk about it. And so it's a simple analysis that the public interest should prevail here, and Mr. Kearney should be included in that and get the benefit of that.
Okay.
So there's no grounds. Thank you.
Gotcha. Okay, what else we got? Anything, Mr. Cosgrove?
I just have one more thing, Your Honor. Judge Rayburn, quite a while.
Yeah, I completely agree with. I'm a bit, because the judge has the discretion here to actually just, yeah, you're correct, because it's most of this is already out there. People have talked about it for a month. What's in the texts, emails, and stuff. So why should Aidan be precluded from doing this just because he's the defendant here? Hey, Brandon, thank you for your $10. Yeah, it's D2 and at least one more doing the same wild stuff. Your crazy stalker from Bastan. Remember, please drink Sam Adams with reckless abandon upon awakening for best result. Sam Adams is a beer, which I enjoy. Samuel Adams Brewery. I'm available for sponsorship. I already put this out there on X and everywhere else that I see people getting, they are getting 100,000 a month for speaking about this thing. And then the other say, they are getting 8,000 a month for speaking about these things. Folks, for only $8,000 a month, I'm prepared to talk about beer. And beer I already drink and enjoy. And I will talk end on how good your beer is. So I will sell myself for beer. Yeah, for only $8,000 a month, if you are a brewery I already enjoy, I will talk very, very well about you on my streams. Oh. Thank you so much, Brandon. Getting us to 27 to the next spin on the wheel. Only 27. Thank you, Brandon. And Brandon, the most important thing here is that you get better. Okay? Soon. What? There's two different beers. Sam Adams or Sam Adnams? I've never heard of the Sam Adnams. Two different beers. I have no idea who that other one is. Sam Adnams. No idea. But if you send me samples and
A while back I want to call the court's attention to this, even though I'm not going to be in the position of litigating it. Judge Rayburn, quite a while back, gave Ms. Gattani leave to file pro se motions with the court. About 3 days or thereabouts after I became aware of my need to withdraw, there was a release of a link to Ms. Gattani's cell phone extraction on the internet, which raised a number of issues, having litigated what should happen with this cell phone extraction rather extensively over the course of this case, raised a number of issues that I would otherwise have proceeded with a motion before the court, specifically as to whether the release by someone, and it was not directly released by Mr. Kearney, violated Judge Krupp's order. Ms. Gattani has filed a pro se motion which sets forth a factual basis for that and asks for certain remedies. I'm not sure I'm on the same page with her as to what the appropriate remedies would be or whether it also violates Your Honor's order, but I do think it raises very substantial questions as to whether there was a violation of Judge Krupp's order, and I would urge the court to take a look at it and consider whether it's worth a hearing date and how the court should proceed. And that's all I'll say about it.
Okay. Have you seen it, Mr. Bradle?
Judge, have I seen,
What was filed by Ms. Gattani?
I have.
All right.
First point, Judge, if I may, is that I don't think Commonwealth Counsel is in any position to argue anything on the
And I don't think he is.
right now.
I think he's would agree with that. So what I'm going to suggest is that should probably be put over to a date where there's a new prosecutor here. I agree with you on that. I think Mr. Cosgrove has correctly moved to withdraw on that case based upon the circumstances. And I think that a new prosecutor comes in, we'll take a look at it, and then make a determination.
Sure.
Okay.
And I don't want to take a lot of Your Honor's time on this, but just so Your Honor is aware of our position, is that Ms. Gattani keeps filing these motions with the court that are creating a serious risk of denying Mr. Kearney of a fair trial, prejudicing him, prejudicing me, prejudicing Mr. Bederow to the court, to the public, and these things keep getting filed by a third-party litigant. There's no privilege in Massachusetts on the part of a third-party litigant to be asking for things like she's asking for in this motion, suppression, a fine, other relief. You know, this is outrageous, and we're going to ask in writing when there's a new prosecutor.
Yeah, why don't you do that? Why don't you
Because we just had it with this. It's going to prejudice our rights to a fair trial on behalf of Mr. Kearney. She can't keep taking pot shots with the court. Your Honor has to read this stuff. You know, it should be stricken. It shouldn't even be accepted, is our position.
All right. So I will then see you back, or someone will see you back on whatever date that is that we chose for the hearing.
And one final thing, Your Honor, I'll put on the record that I told Mr. Bradle and Mr. Bederow that with respect to the most recent indictment against Mr. Kearney that involves him standing outside the pizza shop,
Oh, yeah, 25.
making faces,
Yeah.
that I would provide him with the discovery by the next court date.
Okay.
And that's agreed to, Judge. That's perfectly fine. I did file 2 arraignment motions that I would just ask the Commonwealth to look at in terms of what we're looking for in terms of the response.
Okay. Sounds good. Thank you all.
Thank you, Your Honor.
Your matter is continued to December 5th at 2 p.m. Thank you.
All right. Have a nice day.
Thank you.
Thank you.
All right. Let's see here. I think there are outside of the court. Thank you to the Young Yerks for providing this. Thank you so much. Let's listen to
It's got for us outside the court right now.
Well, that was a lot of. I think we anticipated that the motion to dismiss would be argued in a different case. We would need more time. Of course, it was a mega motion, so it's a lot.
And they haven't responded yet.
They did not respond yet, so they have to respond, like 30 days, and then we're going to argue it on December 5th, it sounds like. So, but, I think the big news out of today was that what we knew was coming, that Robert Cosgrove has tapped out of the Kearney indictments. So,
Yeah, and you guys didn't object to that. So let me ask you this. Let's talk reality here. In 30 days, if they haven't appointed some magical prosecutor, will the court do anything?
This case is on life support. There's no prosecutor. There is literally no prosecutor on the 2024 case. One was removed by the court for making himself a witness. 2 have had to withdraw for various reasons. Alleged victim in that case is suing anybody and everybody in connection with that case. Who's taking that case? Would you?
I will not take that case.
So, look, someone has to show up, but I think also the court recognizes that because of the legal maneuvering, that district attorney doesn't even have the ability to appoint someone because they're apparently going to get sued as well by this individual. So it's a fiasco.
So Judge Doolin made it sound like I'm laying down the law here. 30 days, got to be somebody appointed. Do we really think something will come of it if nothing happens? Nobody's appointed.
Well, something has to happen. Either dismiss or prosecute. One of the two. We have a right to discovery that's still outstanding, and that shouldn't stop because they don't have their house in order. So our position is get your house in order, and if you can't, then do the right thing and dismiss.
Yeah.
End it.
And certainly the defense is prejudiced by that. Let's talk about the most recent case where you're waiting for some discovery. That now they say will be here by the December 5th latest date. What are you expecting to get? This relates to what I call the pizza case.
The window intimidation.
Yes.
So there's grand jury documents. We haven't got them yet, so we don't know what was said in there. And of course, we've seen in the other case that the grand jury is very important. That happens behind closed doors, and if there's shenanigans, we need to be able to identify them and review what happened in there and how I was indicted for witness intimidation for doing T-Rex arms Tuesday night.
But we also want to know on that, the whole case revolves around an apparent illegal wiretap out on the street. So what are they going to do about that? Are they going to charge him? Are they going to give him a break?
Was that rhetorical?
Whoever's in charge of the property.
Let's be clear about that. We asked for an investigation into that, and initially, the Canton Police Commissioner recused herself from consideration of that and kicked it over to the DA, and we filed a notice with the DA to alert them to this, and they simply haven't responded. So, we'll have to wait and see with all of that. But
let me ask about the guts of the motion. We haven't heard the reply yet or the response, and then I assume you guys have the reply. I think the strongest part of it is the misrepresentation to the grand jury. There's a lot in, so is that the key to you, or do you see something more important in the motion that supports getting rid of each charge?
Well, we see a lot of problems in the grand jury, disclosing evidence, relationships with people with very checkered histories that they rely on, destruction of evidence, non-disclosure of evidence, false and misleading testimony. I mean, we could go on and on if you have an hour what the problems are. But, our view is that considered cumulatively, all of this is egregious governmental misconduct, and it all ought to be dismissed. You can't have prosecutors, police officers, private civilians working at the behest or with police officers doing these kinds of things. So I wouldn't isolate it and say this is stronger than that. The whole mosaic is awful and needs to be dismissed.
What do you? Yeah, but you're a good attorney. You always have to anticipate.
I have no idea how they're going to respond to this. In our view, a lot of this misconduct is indefensible. So, but that's for them to decide. I don't want to speak.
We're not giving them any ideas.
How long
Come up with their own.
They're boxed in really well. They're boxed in, and we're very optimistic about it. As we are, they're dropping like flies. Nello's gone, Novak's gone. There's more to come on Nello with respect to the Reed witness case that's still out there to disqualify him there. So there's much more to come. We moved the needle today, kind of mostly by agreement. Again, we're stalled because the government can't get its house in order with prosecutors. So, we're gonna see where that goes.
Every time I come to one of these hearings, I walk out the same way, thinking, "What the hell are they doing, and why? What's the motivation?"
You have to ask them.
I knew you were going to.
None of us understand.
You might have something.
I mean, I'm coming up on the 2-year anniversary of getting arrested at the bus stop, and I don't feel like we've made much progress. They've done anything. Every time we come here, like you said, we just kind of kick the can down the road. And maybe next time we'll talk about something important and discovery. And it's I don't know what their plan here is, but I think it's just to keep me out on bail and keep me on my best behavior, and or I don't even know if they have.
The problem is when they started this case, the idea was to stifle speech as it relates to another. Didn't work out for them, and they're still doing this, and they're kind of stuck with that. As we learned earlier this week, many of the witnesses who presumably are going to testify at a trial here are apparently all about to be sued for civil rights and conspiracy violations. That's another case, other people making those decisions. But you'd like to think at some point in time that you see what happens. We have no prosecutor on one of these tonight. The whole thing is just literally on life support. This other case is kicking around. It's failing. All of this is failing. And you'd like to think at some point that they just reevaluate special prosecutor after special prosecutor after special prosecutor. That appears to be the way the sausage is made in this county. But at some point in some time, it's got to go. It's got to go. The Karen Reed case is over.
They lost. I've heard. I've heard it's time to see the writing on the wall with this case. It was only brought to keep Aidan quiet, and the thing is over. It's circling the drain. And, we want this case has got to go to.
Could the state move it to another county just to keep get a clean?
I've never seen that happen where the state would move a case. I don't think it's going to.
What would that tell you if a prosecutor is afraid that they can't win in their home court, that they want to go someplace else? If that's even part of the thought process, then you should just dismiss it.
Maybe if they move it to North Korea.
Yeah.
So you brought up a good point. Now Morrissey this is ability. So what is the option if the court?
The hell knows. The Attorney General, who has already, as you've seen in the motion again and again, has refused to get involved. Why would anyone in private practice choose to get involved in this? Look what happens. You may get sued. Look, I don't know what they're going to do. It would be foolish to even predict. It seems to me the only right thing to do is dismiss all of it.
Well, they make a lot of taxpayer money, so that's their carrot. So who knows if someone is out there, the fourth or fifth person across all these cases. Are they going to make $250,000 too?
I mean, they paid about $20,000 to work one day. They paid Ken Mello at least $80,000 to do. I don't know what he did, but they just literally took the money and ran. And the taxpayers are the real victims here.
When I sit there and I see all of that money going out the door, it's right.
That's the scandal, though, right? I mean, you have 3 special prosecutors that are now gone from this case. What does that mean? They're not DA salary. That's extra taxpayer money. And one of them got himself kicked off for being a witness. Another one bailed the day after the motion was filed, who worked with Mello. And Mr. Cosgrove understandably had to leave because he's being sued. But you paid for this. It's your tax money that a year and a half later has a case without a prosecutor, and all that extra money went into it. You saw it in Karen's case with all the special prosecutor fees. It's happening here. And maybe the question to ask is, why do they keep doing it? Why does it keep happening here? What's the problem in this county, and why there is such a crisis of confidence in law enforcement here? This shouldn't be happening again and again and again. It becomes a giant fiasco.
That's why all these people are here.
Well, that's where, right, that's what I was gonna say, is that's where you guys come in. The media comes in and the public comes in, that's why you guys are here, because this is outrageous and it needs to stop, and, eventually you get to the ballot box, but you guys are all free to speak out now because, Aidan's not gonna be the scapegoat here. Aidan's not gonna be the martyr. We're gonna get him out of this, and nobody should have to be in that position.
Yeah. That this is really, because now many people know the trials against Karen Reed cost the taxpayers millions and millions. Just Brennan and Aperture is $1.6 million just for the prosecutor and 2 experts who didn't even use their own materials. So they are speaking to the taxpayers. Seriously, talk to your politicians.
Good job, baby. Good job. Well, do it.
Can you do a picture first? And then,
By the way, Mark, I got an hour.
Nice to meet you. Pleasure to meet you. Nice to meet you, finally. Thank you for coming. Good. Just one.
Yeah, I know. Well, I got to call.
So, Aidan, is this what you expected today?
Basically, yeah. I was, maybe we would get into the motion to dismiss, but I was worried he was going to need more time. It was whatever. 3 more months, just kick the can down the road.
Mark promised he'd be the umbrella holder.
Yeah, I'm like the front of the ball. Where are you going? Okay, where's that? Oh, he's walking? Okay. In the registry, I'll drive off. Central? Oh, yeah. So will come to?
Thanks, guys.
Sure.
I don't think that brings us more. Let's hear. How is he lucky? What exactly did he do? What was illegal? No. Aidan Kearney made the mistake of reporting on the Karen Reed case and revealing things that were in the court documents to the public and confronting people. Now, all of these are well within the boundaries of the First Amendment, the freedom of the press. They don't care. There's a lot of places in the world that do not care about the press. United States have one of the absolute best protections for the press in the world. But the state don't like it because they are revealing things. Unless he intimidated witnesses. That's the charges. Yeah, and in Massachusetts, the witness intimidation is extraordinary broad. It's more or less, did you make them uncomfortable? So he has a fight on